Section 72. Process. Once the Commission has received a complaint, they may give a notice of non-referral to the consumer if the complaint is too petty or minor, if the complaint does not apply to the CPA and therefore cannot be fixed, if the complaint is more than 3 years old, or if it is linked to a matter already dealt with by the CPA. The Commission can refer the complaint to ADR or any Consumer Protection Authority or Consumer Court unless the consumer has previously referred the dispute to one of these bodies and it was unsuccessful. The Commission may also refer the complaint to a regulatory body or inspector to investigate the complaint as soon as possible. It can also issue a summons to any party that can assist to provide evidence or information. A search warrant can also be issued if there are grounds to believe that the Act is being disobeyed or if there is information on a premises which is relevant to an investigation. Outcome of investigation. After the completion of an investigation, the Commission may refuse the complaint, refer the matter to the National Prosecuting Authority, refer the matter to the Equality Court, propose a draft solution to the problem to be confirmed by the Tribunal, issue a compliance notice to the offending party, refer the matter to a Consumer Court, refer the matter to the Tribunal. The Tribunal. The Tribunal is the last resort within the problem-solving structures created by the CPA. The Tribunal only deals with serious problems passed on to them by the Commission and certain types of applications allowed by the CPA. The following parties may participate in a hearing: the person with the complaint or applicant, the person responding to the complaint or respondent, any other person who has a material interest in the hearing, if the outcome of the decision or hearing affects them directly. Parties will bear their own costs unless a ruling was made to award the costs to either party. Parties can appear in person or use legal representation, but can be summoned to appear in person if needed. The Tribunal can make the following orders. It can grant interim relief, declare conduct to be prohibited, issue an order to stop prohibited conduct, impose administrative fines, confirm consent orders, pardon non-compliance with its rules and procedures, and any other order to give effect to the consumer's rights. The orders of the Tribunal are binding as if they were made by a High Court and are binding on the Commission, Consumer Courts, Ombuds, ADR agents and Magistrates' Courts. Sections 111 and 112, Penalties and Administrative Fines. Failure to comply with a Tribunal order can attract a fine or imprisonment for a period of not more than 10 years or both. The Tribunal may enforce an administrative fine which does not exceed 10% of the respondent's annual turnover during the preceding financial year, or 1 million rand, whichever is greater. The Tribunal will determine the amount of a fine based on the nature, duration, seriousness and extent of the rule break, the loss or damages suffered, the behaviour and cooperation of the respondent, the market conditions in which it took place, the profits made from the prohibited conduct. Appeal or review steps. A decision by one member of the Tribunal can be appealed to a full panel of the Tribunal. A decision by a full panel can be appealed to the High Court. Notice to appeal must be given within 20 working days after the ruling. Offences and penalties. A supplier can receive an administrative fine of up to 1 million rand or 10% of the annual turnover, whichever is the greatest. It is a criminal offence to alter, omit, obscure, falsify, or remove a displayed price or trade description without authority, or to fail to comply with a compliance notice. The penalty is a fine or imprisonment for up to 12 months or both. An employer may be held jointly liable with an employee if the employee contravened the Act.